Hey folks, James Abrinio, Northern Virginia personal injury and criminal defense lawyer. Today, I want to talk about a national case dealing with a United States House of Representative, a LaMonica McIver. Apparently, she has been charged with felony assault of an immigration officer, and I thought it would be interesting to discuss whether or not what is going on in her case, at least from what we see from the reports or what I've seen from the reports, considered in the context of Virginia assault law. Would that be considered an assault? Would there be a chance of her being convicted here in Virginia? And I think it's useful for folks concerned about Virginia law. Maybe you're facing a charge here in Virginia, you have a friend or family member. You'll kind of get an insight on how I look at things. So while this deals with a federal case dealing with federal immigration officers, there's obviously an analogous situation here in Northern Virginia and Virginia generally. You can be charged with assault on law enforcement. So that's essentially an assault and battery or assault on a law enforcement officer. Oftentimes it's, the standard police officers. Sometimes it's jail officials, things like that. So in Virginia, just to start, if you're charged with an assault or an assault and battery, it is a class 1 misdemeanor. That means up to a year in jail and up to a $2,500 fine. However, if the alleged victim happens to be a law enforcement officer, it's essentially enhanced. So it goes from a misdemeanor to a felony, that there is a mandatory 6 months in jail that you have to serve if you are convicted of assault on law enforcement. And as you'll see, it concerns me because the threshold of what an assault and battery here is in Virginia oftentimes put folks who are charged with assault and law enforcement in a precarious situation where they have a defensible case, but the risk of being convicted, and not only being convicted of felony, but having to serve 6 months in jail, oftentimes compels people charged with assault and law enforcement, even though they believe they're innocent. Even if I think I can win a trial, it compels them to plead guilty, because usually a prosecutor will offer a misdemeanor with some jail time, maybe less than 6 months, maybe no jail time at all. And when you look at the risk reward, I can certainly understand why folks make that decision. While I disagree with it, I can understand. So let's take a second, let's watch some video, and then we'll talk.
You cannot push me. You cannot push me. You cannot
So a few things to think about as we're looking at this case. The first point that I think is important to make under Virginia law when it comes to assault and battery: no injuries are required in order to be convicted of an assault and battery. A push, a shove, a smack. If you're just charged with an assault, you don't even have to have physical contact, so long as you either take an overt act intending to put somebody in fear, and you have a present sense ability to be able to do that. So you don't even need an actual physical touching for an assault. So let's say you're swinging at somebody and then they cower in fear. That's technically an assault. So when I look at a video like this, what concerns me from a defense standpoint, if I'm defending this Representative McIver, I'm looking at this and I'm thinking, even though there's no physical injury, there is touching. Now, another question I have is, who is the actual victim here, right? As you can see, there's multiple individuals. There appears to be multiple ICE officers. I don't know who's the actual complaining witness here saying that I was assaulted. Obviously, I pulled this up on a YouTube short, so we clearly don't have all of the video as well. What I would like to know is what led up to this, whether or not there's different angles, which I'm sure there are different angles. at least here in Virginia, if something like this were to happen, let's say there was a bunch of law enforcement officers and there was a scuffle and pushing and shoving, each officer would likely have his or her own body cam video. So you would have multiple different angles that you'd be able to look at this and see what exactly was the touching, what led up to the touching, because that's also important as well. I want to know exactly the context of what led into this altercation as well. There are even though the question about whether or not it's technically an assault and battery under Virginia law is obviously, it appears to be sort of black and white, the context matters as well. So if you have physical contact with somebody, but it's not intended to hurt them, let's say you're either defending yourself, that's kind of the traditional one, somebody's coming at you, so you hit them back. But also, I think here there's a lot of pushing and shoving. There's a lot of yelling. I don't know exactly what's being said. I don't know the context of it. But looking at that, I'm thinking in my mind, I don't know that she intended to touch anybody at all. It seems like she's being pushed back and forth. Everybody's getting pushed back and forth. I'm not sure exactly who's doing the pushing and when the pushing started. Clearly, people are being moved back and forth. So it's hard to tell from these angles, or this one angle, the context. I think from a defense perspective, that's good for her. The traditional rearing up and punching somebody in the face, I don't see that here. The traditional, I'm going to buck up and run at somebody, I don't really see that here. Again, I do see touching, but it's a lot of back and forth, a lot of pushing and shoving. You're not exactly sure where it went. Now, against her argument is the fact that, and again, I don't know the exact context, but there are clearly a lot of law enforcement there here, ICE agents. Whatever you're feeling about the justification here or not, whenever you have a bunch of law enforcement officers and then you have an individual put themselves in that situation, the prosecution will argue they essentially expected there to be touching and law enforcement's telling them to step back. And so therefore that should be enough for an assault. That's what the prosecution is going to argue. Now, I would obviously argue counter to that if I'm defending her, that this is a public, depending on where this is, but it's a public place. She's also a public representative. She represents constituents, and she actually has the right to be there, and she should be there representing her constituents. Just because this is a place where ICE or law enforcement wants to be doesn't mean that that gives them the right to be there. Even if they have the right to be there, maybe they do. Again, I don't know the full context of this, but even if they have the right to be there, that doesn't exclude her right to be there. And again, I also don't know exactly what's happening in the full context of how we got to this commotion. Has there been area blocked off where only law enforcement saying they should be there? Has she already been told that she needs to leave? And in a situation where it's reasonable for them to do that? Again, there's just a lot going on there. I would also want to know what exactly the alleged victim here, the alleged ICE officer that allegedly was assaulted, I want to know what exactly he's saying happened. Even though, again, as I said earlier, physical injury is not required here in Virginia, physical marking is not required, and actual touching is not even required. I want to know exactly what that officer is going to say. I want to know if he's claiming injury or not, because I think though it's not required, it's useful, especially when I'm defending the case, particularly if there's no injuries, where it's not, even though arguably there's theory of physical touching and there's arguably an assault there that a prosecutor can make, and maybe they get a jury to buy it. There's clearly no injury here, unless, again, there's nothing being reported, at least, but there's clearly not any serious physical injury, meaning nobody was, not that I'm aware of, taken to the hospital, no broken bones, cuts, things like that, bruised eyes and things like that. It looks more like a push and shoving situation. I also understand that there's a lot of politics behind this, but I would also be concerned as a prosecutor. You're taking a criminal charge against a public representative who is there to represent their constituents. You may not agree with their politics. You may think that's inappropriate, but I think that the circumstances here, at least in my mind, is there's clearly some political motivation behind bringing this charge. And taking off my, political viewpoint, I'm thinking, what am I saying in front of a jury? How do I get in front of a jury? Because if in a case like this, if my client said to me, let's say they were charged with assault and battery, a law enforcement officer, and my client said to me, James, I want to go ahead and go to trial. I'm innocent of this. I'm willing to risk a felony conviction. I'm willing to risk 6 months in jail. I would love to get in that front of a jury because I want to give them the full context of what's happening. I want to point out, and look, again, even if you can see that there is the law allows for an assault and battery, you still have to have the intent to assault and batter here in Virginia. You can't just say, oh, well, there's a bunch of pushing and shoving and she shouldn't have been there, therefore she's guilty of an assault. I don't buy that. Maybe there's some other charge, obstruction, things like that they could look into. But I think it would be interesting. It would be a really fun case to try in front of a jury. But then there comes that caveat. And this is my concern about the charge of assault and law enforcement officer here in Virginia, is the threshold is so low where you can I've seen cases with even less substantial facts here where my client was charged with even less serious situation. And because, again, the threshold is so low for them to be convicted, I did have to tell them there's risk. And sometimes they said, I don't want to go to trial. I'd rather take a plea. And that, which involves a misdemeanor and minimal jail time and things like that, which I find just a travesty. But ultimately, as an attorney, my job is not to tell a client, can they accept a plea or should they accept a plea? I can advise them of what things they should be thinking about. I could advise them about, do I think I'm going to win or lose and all that. But ultimately, it is the client's decision about whether or not to go to trial on assault, especially assault and law enforcement officer case. So that's the same discussion I'd be having if Representative McIver was my client and it wasn't Representative McIver, it was Joe Schmo or Jane Smith, and she was charged with assault on law enforcement officer because some other circumstances, let's say she was being investigated for a drunken public, or he was being investigated for a theft, and then there was some physical interaction. That's the kind of cases that, as an attorney here in Virginia doing mostly state work, those are the kinds of cases that I oftentimes deal with, where it's really less politically charged situations, where it's more day-to-day things where somebody's wrongfully charged. Just because it's not making the news does not mean it's not important, does not mean it's not life-changing. In fact, everybody that I represent when it comes to serious assault cases, this is one of the most serious events in their life. It has devastating effects with their job prospects, with security clearances, with licensures, all that. So it's a very, very sensitive situation to be in. Now, ultimately, if I have a client that I'm representing in a situation like this, what am I hoping happens? Would it be interesting to try the case? Absolutely. If I had a client especially willing to go to trial on that, assault and law enforcement. What if, though, and oftentimes this is part of the job of defense counsel, is trying to find creative solutions to mitigate risk. What if I could convince a prosecutor, let's continue the case for 6 months. Let my client do some community service, maybe some anger management, even if he or she's not guilty. And I think the charge is, pardon my language, chicken shit. Even if that's the situation, but I can get an offer that involves the case being continued for 6 months and then being outright dropped and expungible, and a prosecutor's on board for that. That's probably a situation where it's going to be hard to turn down, even if the risk of losing is minimal, because and we call that here in Virginia general continuance, where there's no finding by a judge. There's essentially a private agreement between me and the prosecutor, where even if they screw up and they come back, all it means is we're resetting the chessboard, and then we can still go to trial. We haven't lost anything. If in those situations where my client hasn't lost anything, usually I'm recommending them to take that, even if they got to do a little bit of work, even in a little bit of community service, because at the end of the day, it's not worth the risk. I think any trial attorney that's tried cases with regularity, that's not just tried cases that were even slam dunks, but even those situations, any trial attorney knows that juries and judges get things wrong. Can't tell you how many times that I've stood in front of a judge or a jury, either a motion or a trial, knowing that I've won it as soon as I said my last word, and then only the outcome comes and being completely surprised. Again, any trial attorney that actually has tried a number of cases has been in that same situation. And if they're telling you they haven't, that means either they're lying or they haven't tried enough cases. Juries, while I trust them oftentimes better than judges, while our jury system is probably the best in the world, relatively speaking, while I trust the jury system better than just trusting the government to get it right, the jury system is human and it is flawed, and errors are made all the time. As you open up the newspaper, if you look at online, there's countless people, innocent people sitting in jail wrongfully convicted as we speak. So you always have to recognize that risk. So look, there's this short video that we watched in this case. From a Virginia criminal defense standpoint, if this were a Virginia charge, it raises more questions than it answers for me. If I had a client calling and showing me this video, I wouldn't be able to give them an answer right then and there. I would want to conduct what we call discovery, where I'm requesting all the video, I'm calling witnesses, I'm seeing how my own client testifies. I'm seeing what statements were made, whether it's written or in report, to see if what the alleged victim is saying. If they went to the hospital, I'm subpoenaing records to see what they've told law enforcement, told the medical providers, because I want to see if they've given inconsistent statements. I want to look at their motivation. Why are they doing this? And so you take it at every angle. Now, is it true? Some of the pushback I get, and I understand that. I personally do think that our Virginia assault and law enforcement officer statute is concerning because it's both a felony and a 6-month mandatory sentence with such a low threshold of being convicted. I think that puts individual citizens in precarious situations. I also think that if an assault is significant enough against the law enforcement officer, there are other felony charges that can be brought, or if it's a misdemeanor, there are prosecutors that will look for significant. I mean, you can get up to a year in jail. I do think that we need some modification to our assault and law enforcement officer statute, if nothing else, to take away the 6-month minimum sentence. That way, you don't have people that are substantially likely to be acquitted being compelled to plead guilty just because the risks are too high. And I don't think that that's what the majority of Virginians want. Now, I'm sure I'm going to get pushback on this, and folks are going to say, I don't care about law enforcement and I don't care about protecting people that serve. Look, I do injury work as well. I represent victims that are injured in crimes and accidents and things like that. I work with law enforcement all the time. Their investigations oftentimes is vital for my civil clients getting recourse, because their investigation is the foundation of what I do. Their involvement is vital. Oftentimes they're star witnesses in trials. I know that they have a very difficult job. They're pushed around and disrespected by folks like me, defense attorneys, when we're trying cases against them. They get blamed for things that are not their fault. In many times they disagree with here in Virginia, we call them Commonwealth attorneys, the prosecutors. So I empathize with law enforcement. But at the end of the day, what I want, 1,000-foot view, is a fairer system for everybody. As a practicing attorney here in Northern Virginia, representing all kinds of individuals, black and white, rich and poor, Democrat, Republican, anarchist to neoliberals, to whatever you want to call it. Frankly, I don't care about the political leanings of my client, so long as they're not actively trying to harm people or the Constitution. I think everybody deserves a zealous defense. Look, I hope this was useful, and I didn't mean to get tangent off into politics. But this would be a super interesting case to try from a Virginia standpoint. Hopefully you found this useful. If you did, make sure to subscribe to the YouTube channel. If you disagree, feel free to comment below. All I ask is be respectful. I'm starting to get all these random comments about just odd things, and you do you. I'm not going to fight you on the internet or whatever. It's a free world, free speech, all that jazz. Do what you need to do, but the goal here is to have interesting discourse, hopefully educate a few people. And for you folks watching this, if you've got a family member charged, you're charged, hopefully this helps you kind of understand a little bit more of at least my thinking about how assault and law enforcement works here in Virginia. Maybe it's useful. Feel free to call with questions and all that. I wish you the best, and take care.